Hello for the second time today already. And it's only just 7 o'clock a.m. here in Aussie land. And it's Saturday here in Aussie land as well. Amazing. I've already done one stream today and we're here for the second one. It is the Bryan Kohberger hearing PM session because the AM session was sealed, baby. And the PM session is apparently about to be streamed from Judge's YouTube page. And what better place to watch it than here on EU's channel with my guests. Guests. Hello, guests.
Hi.
Hello.
Don't look so surprised, darling. Why do you look so surprised?
I'm always
We're
surprised.
always shocked.
And Mo is here. Hey, Mo.
Hey.
How's it going? Good to see you.
I feel naked. I don't have a wig on. I don't know what to do with myself.
You look beautiful. You look beautiful. Beautiful.
Thanks.
We've got people watching, but we've got no chatters. That's strange. I hope I haven't boomered.
No, I
It's like very weird out there. Can someone? Oh, there we go! Yay!
I was like, has Texas declared? Are we on full on?
Are we in Civil War?
Okay, good. I just wanted to make sure because the other day I did boomer the chat, so I did massively boomer the chat. But just want to make sure that people can actually chat. Thank you. Good.
I'm
Did you
just
send-
proud of you. You handled it much better than me crying in the corner because that's what I would have been doing.
Would you?
Did you send Bronca a link?
I haven't sent Bronca a new link yet. I will do it now. But why is he in chat already?
No, I just.
Okay,
yeah.
good. No, I will in a minute. It's not really much point just yet because we have no live feed. Anyway, I'm sure it's coming any second. Okay, so
Now,
Phrasing.
sorry. Hello, good morning, Tragic. Yes, good morning. Happy day after Aussie Day. I didn't even notice any of the garbage that was going on for Aussie Day. Things happen in Australia on Aussie Day. Lots of people like to argue.
Racist
But
day.
some people, yeah.
Oh,
some
I
people
was
like
about to
have
say, do you guys
barbecue.
like fireworks? Or
Yeah, there's a bit of fireworks sometimes. There's
No, they
fireworks
just
in-
scream racism at each other.
Yeah, people scream racism at each other. All sorts of things
Well,
happen.
what?
Where, by the way, a cute thing that's been happening as a result of all the arguing that happens on Australia Day is we're thinking about changing the date of Australia Day to May 8th. Guess why? Mate. May
Okay.
the 8th.
that you know
mate.
what? That would be cute.
It's
Aw.
pretty cute, right?
Then you can punch each other while calling yourselves mates.
So guess what day it is, mate? I think we all just think that's really funny. And if we're going to change the date, it should be mate.
Yeah,
Mate,
I mean,
mate.
why?
Mate.
I mean, it seems like a better idea than a lot of the other ones I've heard from many governments.
It's pretty good. We have a sense of humor here. So rather than argue, let's just make the date a joke. Why not? Okay. You think the whole entire interwebs are streaming this hearing? Well, it'd be good if Judge would actually put a live stream up. Then the entire interwebs could stream the hearing. That'd be fantastic. I
So-
only know of Danny streaming it. I don't really know of anyone else in our circle. Don't really know who else is streaming it. Oh, well, EDB. I know EDB is going to be streaming it. But she was just on News Nation, I think it was, or I can't remember which other. What was the one that we were just watching, darling?
Yeah, Danny does not have a feed yet either. So
No one's got a feed. We're looking at the stream, and there's no feed, so everyone's going to be coming from the same feed. Because, okay, just so everybody is aware, the way this works is Judge, who is the judge,
a judge,
because his name is Judge, in Latah County, Idaho, he made a ruling about a month, 6 weeks ago, saying that there will be no court TV, there will be no law and crime, there'll be no other cameras in this courtroom except my cameras. My camera,
Okay.
right? And so you guys can stream what I put out there, but they're my cameras. So basically, they FAFO'd, as Andrew Burkett said.
Basically, he's going to piss on every corner of the camera. Oh, wait,
Yeah,
wrong trial.
Wrong trial. Hello, CC. And Rosie, you're back. You're still here, basically. Yeah, Danny, EDB, and recovery addict that I've seen. Yeah, fair enough. That makes sense. Yes, so long story short, you know that there'd been a lot of conjecture as to whether there was even going to be streaming of this trial, whether or not we were going to see it. And we really, really needed to see this trial. There has been so much shenanigans going back and forth about this, about the testimony in this trial, about the evidence, about the DNA, about whether or not the state has been playing games. And then, of course, lots of people are saying that the defense is playing games. And really, in order for there to be transparency, the only way is for us to actually be able to see what's going on. And so Judge was in a bit of a rock and a hard place, because really the situation was that no matter what he did, the cameras, like the mainstream media cameras that were coming in, all they would do is they'd come in and they'd just look at Bryan Kohberger and they'd look at him tight in like this. So they go like that all the time. And the issue with that is then the pod, yeah, like that, Dali. Yes, like that. Like that, exactly. It's scary. And then they'd say, oh, when he does this, that means that he is hiding something. He's hiding something. He's so guilty. He's so guilty. That's a guilty mouth tick.
How do I fix this now? God damn it.
Guilty mouth tick. Look at how guilty he is. He's such a monster. Right? And it really was out of control. It was so out of control. In fact, it's still out of control. The way people are analyzing his every movement. And so it has to stop. And Judge told them to stop many times. He told them to stop. He said, stop focusing on the defendant. This is a court proceeding. People there were witnesses testifying and things like that. Yeah, you keep just going like that all the time. It's ridiculous. This is not some sort of circus. And that's not his words. I'm just paraphrasing in my own way. But they kept doing it. And so he was, yes, between a rock and a hard place in that he wanted there to be transparency, yet there was this problem with the cameras. And so, yeah, basically the cameras, they just kept doing it. And like I said, they effed around and they found out. And he said, you know what? Fine. I will just put my potato cameras up and you can watch those, because they're not going to zoom in on the defendant. They're not going to give you your juicy, spicy images that you can zoom in on. Sorry. But you get to see what's happening. No problem. And you know what? I'm fine with that, because as long as there's decent audio, please let there be decent audio. Please let there be decent audio. As long as there's decent audio, I'm cool. Right, guys?
Yeah.
Yeah, I mean, I think maybe it's time that, and I don't know who the governing body would be. I don't know if there needs to be a governing body, but I think there needs to be a sort of unified court decorum rules for filming for court TV and these people, because I think they keep doing the same thing. They keep screwing up in trials. So
you found it?
We're on. Sorry. You're right. No problem. We are on. Oh my God, is there a chat? Oh, we don't want that. Oh no, it's not chat. Okay. Okay, let's get some sound happening.
So we're here. This is an open
We're
case.
queer. Get used to
You
it.
probably
Oh,
know
wait.
we had a closed hearing
Different
this morning,
meetings,
and that was necessary because that was related to the grand jury, which is secret. So that's what that was all about.
Secrets are no fun unless you share with everyone.
I'm assuming that you have all seen the
How's audio, guys?
amended order governing courthouse and courtroom conduct. We made some changes, and you probably also know that we are streaming now, and that is on a YouTube channel. If you don't know that, you can
God, I
go
love
to
it
the
when
court.
people
the
like me
Supreme
and
Court,
boomers talk about YouTube like it's a miracle.
This
I guess,
infernal machine.
website, and you can get that that channel if you don't have that already. So
But I love how I'm so proud of it, and
you
this
don't want to
judge
be
is too.
on a camera. You probably
I'm a
shouldn't,
streamer.
but
And
generally
you too can be an
we can't
influencer.
see very
We might
well
turn our own audio down a little bit.
farther
Sorry.
back in the courtroom. So just so you're aware of that. So today we are addressing reconsideration of the order denying motion to dismiss the indictment, and that order is focused on the claim of inaccurate instructions to grand jury. Also coupled on that is the
That's right. Over.
potential for permission for appeal for interlocutory order. So, and a stay of proceeding in the case.
Or Ashley and Alyssa, they get
I think
huge
that's all
close-ups.
the preliminary. So, Ms. Taylor.
Mr. Logston will be arguing, Your Honor.
Okay, Mr. Logston.
I'm gonna, I guess, be succinct since we argued almost the very same thing this morning. But
It sure is.
in essence, what we're asking the court to do is to give us the court's blessing to take up the issue to the Idaho Supreme Court. I think the court has noted that it's certainly an interesting issue. The Idaho Supreme Court does have a rule that essentially lays out that this is to be done in very rare circumstances, important issues where people may disagree and that may make it more orderly in a particular case. Our argument is that for this case to exist, the indictment needs to be valid. If there's something wrong with the indictment, that's something that certainly should be addressed. We're also concerned about the fact that there is case law that says that if this case goes to trial, issues with the indictment may become essentially mooted by that and would never be answered. And there's relatively little in the way of case law in Idaho in the last 20, 30, 40 years. And so without permission to appeal, we may never get an answer on this. And certainly that's very important to Mr. Kohberger, because whether or not there's a valid indictment in this case is going to decide whether or not he sits here and whether or not a trial should occur, et cetera. One of the major issues is whether or not that's going to have an issue with the timeliness of this case. And my understanding is that's going to be the next argument that comes after this one. And so we believe if a trial is set out as far as we think it ought to be, that an appeal at this point won't disturb where we think a trial should occur in any case. And in any matter, this isn't our attempt to achieve some delay. This is our attempt to make sure that our client is getting due process at every step in this case, and that nothing is being left, no stone left unturned. Thank you, Judge.
Thank you, Mr. Logston. Mr. Nye.
Thank you, Your Honor. I want to start with the rule that was just referenced. It's Idaho Appellate Rule 12, and it governs interlocutory appeals. And the criteria in that rule set out two factors the court is supposed to consider. The first is whether or not there are substantial grounds for difference of opinion. And on this particular issue, as the court stated in its order, the standard of proof for grand juries in Idaho has been consistently probable cause for at least 3 decades. That doesn't sound like substantial grounds for a difference of opinion. And in fact, the defense conceded in their opening brief on this issue that, quote, the whole of modern jurisprudence on this issue is against this novel theory that they've raised. So they haven't met that first factor. The second one asks whether an immediate appeal may materially advance the orderly resolution of the litigation. And I have not yet seen in their briefing or heard in their argument any path forward for them in which winning this appeal materially advances this litigation. I think if we're all being honest with ourselves, a trial in this case is going to happen. And the question is when. And if we send this case up on appeal, even if the defendant wins, the law clearly allows for us to bring the case back. Even if the Idaho Supreme Court goes out on a limb and says, you're right, the standard of proof in a grand jury should be beyond a reasonable doubt, we could use a normal complaint and probable cause hearing in front of a judge. So it would be the same standard yet again, and we would go in a whole circle, basically resetting the case to be where we're at today. We need to get to a trial in this case. And that brings me to my final point. I'll also try and keep this short. There are
Why start now?
secondary factors that the Idaho Supreme Court has looked to in addition to that rule, even when those first 2 factors are met, to decide, is this actually the case that we want to take an interlocutory appeal? And my read of those secondary factors is it's really asking, like, what is the effect of this appeal on the litigation and on the parties and those involved? And I would just like to point out to the courts, under the rules, this is Idaho Appellate Rule 13F, and it's talking about the stay upon permissive appeal. And it says in F sub 2 that the granting of a motion for permission to appeal under Rule 12 by the Supreme Court automatically stays the entire action or proceeding until the appeal is terminated. So at that point, there's no more discretion. It automatically is this case. Hits the pause button. But more than that, Your Honor, it continues and says, and during that time, the district court or administrative agency shall have no power or authority over the action or proceeding. We're not just talking about a stay in the proceedings. We are talking about this court losing its power and authority over this case while the appeal makes its way through the appellate process. That is going to cause significant delay.
Guys, check out the banner.
We're about to have an argument or a conversation at least about scheduling. And there is a lot that needs to be done before this trial happens. And this court will have no power to address those issues if this case is pending on appeal. Now, in full disclosure, there are some exceptions to that rule, but it's the exact same exceptions that apply to an appeal as of right after judgment. So it's things like you can change the sentence, you can sentence the defendant, you can change bail, things like that. But for discovery, we've had the genetic genealogy issue that's still out there. We're working and making progress on, but pause button on that, pause button on discovery, pause button on change of venue, pause button on motions about experts and who can say what. It would significantly delay this litigation, which brings me to my final point, and that is I don't want to lose sight of the fact of the seriousness of this case. We are talking about a quadruple homicide under Idaho's law. Not only are those who were killed victims, but every single one of their immediate family members is a victim.
On the table.
And in this state, in Idaho, our victims have a constitutional right to a timely resolution of the litigation. We are already quite a ways out. And the idea that we would hit the pause button and take power away from this court because there is a interesting issue for the Idaho Supreme Court to address is not something that this court or any court should tolerate. It's time for a trial, Your Honor. Thank you.
Mr. Nye.
Okay.
Mr. Logsdon? Reply?
Judge, once again, we believe this to be an important issue and one that is worth getting a glance, at least from a higher court, rather than being tucked away and forgotten in the maelstrom that is to come. As the state undoubtedly knows, trial won't put an end to this case. This case will go on for 28 years if they do actually achieve a conviction. So the idea that somehow we're running towards something and that's going to do anybody any good from their standpoint is, I think, false. What we're trying to do is make sure that the things that occur in this case are done correctly. And
Yes.
if you want to talk about how long things are going to take, get some stuff wrong and then see how long it all takes. We're asking that the court would give us permission to go and see if the Idaho Supreme Court would be willing to weigh in
100%
on this
up for that.
particular subject. Whether or not the case makes its way to trial at some point is, in our mind, just part of
Right
what
on
the court
line.
has to look at, particularly in a case where the state's decided that it wants to try to kill someone. Thank you.
Excuse me.
100%. Seriously.
Well, first of all,
Life.
this is a reconsideration of the order relating to dismissing the indictment, whether or not the standard for proof on a grand jury is probable cause or beyond reasonable doubt. I don't think we've done anything wrong about that. That decision was put out quite a while ago. It's rooted in well-settled law. And I think it was correct. Supreme Court, I guess, could turn that around, but that is doubtful in my opinion. We went through Idaho Constitution, statutes, case law, criminal laws, and really common sense. So I feel quite confident that that was a correct decision. So that established that it is well established that the standard of proof for indictment in the grand jury is probable cause, not beyond a reasonable doubt, which is the standard for trial. So putting that aside, now we get to this permission to appeal under Rule 12. So, excuse me, let me just get this in front of me. So the criteria for permission to appeal, this is in Rule 12 of the Idaho Appellate Rules. First of all, it's very, very rare in case law for such an appeal going to the Supreme Court. It does happen, but it is rare. And the court has established this criteria. And I'll just read this part of this. The issue needs to involve a controlling question of law as to which there is substantial grounds for difference of opinion. Again, in my opinion, and based in all the law in Idaho that I've found, is that there's not a difference of opinion about what the standard for the grand jury is. So the defense is making that argument. I respect that. I don't agree with that, but that's where this is. I don't see a difference of opinion throughout the state about what the standard is for grand jury determining an indictment. But this also has a second component. And this is something that Mr. Nye really focused on, is which an immediate appeal from the order may materially advance the orderly resolution of the litigation. And I'm very concerned about delay. And I think that if we send this to the Supreme Court that it's going to add delay. Mr. Logston is correct. I mean, this is a complicated case. It could take a long time, longer than any of us want. But I think that would add additional delay. And as I said, I'm already concerned about that. We're over a year. Could be another year. I'll just let you all know that. Now, even if the Supreme Court takes up this appeal, or I deny it, and I'm going to deny the permissive nature of this. If I deny it, the Supreme Court can still pick up the appeal. That's up to them. But they do look at what the district judge's opinion may have some bearing on that. I hope so. But they could still overturn the orders of this court denying the motions to dismiss the indictment. And they could dismiss the indictment. What would happen then? Okay, is this going to really materially advance the orderly resolution of the litigation? The state could just file it, refile it, as Mr. Knight said. So that's significantly more delay. So there's some other, actually, this is in a case law, Buttle versus Todd, where it's an old case, 1983, but the court also considers other factors, including the impact of the immediate appeal upon the parties, the effect of the delay of proceedings in the district court pending the appeal, the likelihood or possibility of second appeal after judgment is finally entered by the district court, and the case workload of the appellate courts. But it finishes with an appeal must be exceptional.
Yes, of course.
Seeking of that appeal.
He asked for an invite. I've sent
Because the Supreme Court doesn't broaden the appeals,
I expect.
which may be taken as a matter of right under Rule 11.
Correct.
So, in my opinion, I do not find that the criteria is satisfied for a permissive appeal. There's no controlling question of law where there is substantial grounds for difference of opinion. The law is settled as far as I'm concerned, and there's no difference that I'm aware of. I also do not see how the appeal could advance the case. To the contrary, it would stall the process when we really need to move forward. So I'm denying the permission for appeal, but obviously denying the motion to reconsider.
Ah, okay, just like that.
And with that, I think we are ready to go to setting a trial, or
What?
at least a schedule order. So anything else about this issue before we go to that? Ms. Taylor?
No, Your Honor, thank you.
Mr. Thompson?
No, sir.
You want to go first, Mr. Thompson, about the state's position
We could have a
on
trial date today.
scheduling?
Yes, sir. I'd be happy to. And to start, Mr. Lodgen said something that I think needs to be addressed. He makes the allegation the state is trying to kill someone here, and frankly, I find that offensive. What the state is trying to do is to enforce the law that our legislature has put in place. It says, in cases such as this, with facts like this, a jury is entitled to decide not only guilt, but potential felony. We are simply trying to fulfill our responsibilities under the law. To characterize it as the state is trying to kill someone, is just simply appealing to raw emotion, and it has no place in this court. We would ask that that not be allowed any further. Now, as to the trial,
It damn well seems like
Ms.
it.
Niner already noted that we have a variety of competing interests here. We have certainly the defendant's right to a speedy trial, which he has waived at this point. There are also interests of the state itself, and I think even more importantly, the victims and the families of the victims in this case to a timely disposition of this case.
Wait, did he
Granted,
just make
this
it
is a
more
complicated
important
case.
the
It is a
victim's
very
rights, not
serious
the
case.
defendant's right?
And a lot of
I was gonna
effort
sign
needs
you
to
up a little
rightly
bit, Mo.
be put into it to make
Oh.
sure that the case is handled correctly. At the same time, we need to also balance the need to move forward in a constructive, productive fashion. When the state filed our motion asking for a scheduling order and trial date, which was a little bit over a month ago, we proposed the summer of this year. And at that time, at this time right now, we believe that we could be prepared for trial summer of this year. We realize defense has factors and considerations they want you, Your Honor, to take into account, and certainly we want to afford them that opportunity. I will say, though, that, and that we touched on this in our motion, in our request for the scheduling order, that given the nature of this case, if we are going to try this case effectively with minimal unnecessary harm or disruption to our community, it should be done during the summertime. And I say that because right across the street there is Moscow High School that shares parking all around the courthouse with everybody else who's going to have an interest in this case and being here. And we've already encountered the conflict between those interests. We can't sustain that for weeks and weeks on end. That's just not fair to the students. It's not fair to the school district. It's not fair to the media. It's not fair to anybody. The other factor is, as Your Honor knows, we have two universities, part of our community. And during the academic year, we have graduations. We have numerous sporting events and other university-related events that essentially consume every available hotel or motel room.
Okay, so we're
within
worried
miles.
about all that stuff. How about
This
we
case is
worry
going to involve bringing in people from out of
His
state,
rights
numerous witnesses
to
from
be
out of state
prepared.
who will have to be put up in lodge. And we would submit that that's going to be unnecessarily complicated if trial occurs while the universities are in session.
Yeah,
So those are the considerations that we have, Your Honor. As I said, we filed this last month at that time, and as we stand here today, we believe that we could be ready for trial this summer.
Forget
Thank you, sir.
summer.
Thank you, Mr. Thompson.
Okay,
Sorry, I'm getting really
Thank you.
upset.
Your Honor, I received Mr. Thompson's motion for a scheduling order, and I had the opportunity to meet with him and
so
talk with him and Ms.
rights,
Jennings
parking
about that.
matters.
So it is no surprise to the prosecution
Yep, that's
that
it.
we do not believe a summer of 2024 trial is realistic in any way.
Thank you. And
Understanding the state's concerns, if a trial were to happen in Latah County, we would suggest looking at summer of 2025. However, council and the court's aware that our intention is to file a motion for change of venue. That hasn't been filed yet because we're not ready to have that heard yet. There's work that has to be done to present to the court and council in support of that. So that's just for the court's information. Your Honor, that in the state's scheduling order, it asks the court for various things. And a lot of those we don't have disagreement with. We think they're appropriate. And in fact, they were things that were covered by the court in the court's original scheduling order. As the court and council recalls, last fall, we had not made the choice to waive speedy trial. And so the court did a scheduling order at that time. It wasn't but a few days later that we'd had enough time to discuss that. And Mr. Kohberger decided to waive his speedy trial, and the court vacated that order. So I'm familiar with what the court likes to put out there as far as a scheduling order, and I don't think there's a problem with that. I would want to inform the court that I do not believe this is a 6-week trial. I believe this is more like a 12 to 15-week trial. This is, as everybody said today, a very complicated case. And I want to talk a little bit about what drives both our request no sooner than summer of 2025. And I say that with fear, Your Honor. There are a lot of things that we have to still do. I want the court and council to know that we haven't sat around waiting for a scheduling conference to begin doing those things. We have been on this case and active and seeking discovery and reviewing discovery, meeting with experts and working the case since the day we were assigned this case. So with that said, there's still plenty to do. And I want to talk a little bit specifically about that. In a case where there is the potential for a death penalty, we're looking at two tracks of trial. We're looking at the innocence phase, where there's tons of witnesses and a lot of things that happen. And if there is a guilty verdict, we immediately go to a sentencing phase. That's up to the jury what happens there, but both parties have to be ready to proceed forward. So we don't get the luxury of focusing on our case, the state's investigation, our own investigation solely. We focus on that. We are working on that, but we are required to begin our mitigation case. That's what it's called, the penalty case. We are to put on mitigation. We are guided by the ABA standards, American Bar Association standards, in capital cases. That's what this is. A death penalty case is a capital case. And we're guided by those standards. And they tell us that as attorneys, we must investigate every aspect of the case in the innocence phase. We must meet with our client regularly, which we do. We must engage in experts and understand the issues that are coming, which we are. The American Bar Association guidelines in capital cases say we must hire a mitigator, and there must be a mitigation investigation. We hired a mitigator, probably one of the very first people we contacted. And so that has been ongoing for 13 months almost as well. We have not been sitting back and waiting. Your Honor, in this case, the complexities are that there are special areas of focus. And when we get to trial, counsel for the state will put on experts to educate the jury on specific areas of focus, as will we. And it takes a while to get all of that done. In addition to that, as the court knows, everything is recorded. There's digital footprints all over the place. And so we have a lot of records that we have to go through. I know that the court has heard about 51 terabytes of information that we've received. And I want to tell you what that means. Ms. Massa found a statistic for me, and I want to tell you how much 51 terabytes of data is. And she found that. She was looking at Dropbox.com, and 51 terabytes of our discovery, to put it in perspective, 1 terabyte can hold 250,000 pictures. 1 terabyte, and we have 51 of those. Or 500 hours of high definition video. And we just have one of those. So 500 hours times 51, or 6.5 million document pages. And that's equal to 1,300 filing cabinets. And we have 51 terabytes, not just one. So that's a lot. There's specialized knowledge. There's a lot to go through in this case. We also have another player in the case, and that's the presence of the media. This is a case that has drawn a ton of attention from the media, and it continues to do so. And I don't think that's stopping anytime soon.
Point outline.
The impact of that is that we have found that when we want to talk to witnesses, sometimes they don't want anything to do with us. Sometimes they're people that have already talked to the media too much, and so we shouldn't talk to them or bring them into the case. Mm-hmm. So that's just a complication. We're working through it. We're working around it. But that's something that the court has to be aware of. I want to let the court know that there are over 400 potential witnesses in the innocence phase alone. I personally and my team have talked to less than 10%, well, less than 10% of those witnesses. In the mitigation phase, our mitigation expert has been actively working the case. We've all been working alongside our mitigation expert. There are still well over 100 people left to try to contact and try to interview. And let me back up and explain what we do with mitigation. We are to learn Bryan's life story. We are to go all the way back to before he was born and learn his life story.
We'll pause for just a second and say hello to Mr. Potentially Criminal.
Hey, are we doing Bryan Kohberger, or are we doing the Murdaugh stuff? I know you sent me a...
No.
Oh, okay.
I sent Murdaugh's over for now.
Okay, I just want to make sure. Sorry, I've been out.
Yeah. Topic is right. So we're watching the Murdaugh hearing right now, and things are getting a bit crazy. We're starting to talk about the trial date. And basically, just to bring you up to speed, the state has gone and said, well, the victims have a, I don't know if he said right, but they deserve to have expediency in having this trial sorted out, basically, and they want to, they want summer this year. We want summer this year. And Taylor is now rebutting that and saying, look, that's 5 months away. There's a lot of discovery that has not been handed over yet. There's some 61 terabytes of video data. There's all this DNA evidence. No, we would be, if you want summer, you'd be looking at summer 2025. Or we'd be looking at a change of venue, which we would need to put in a motion for. So we've not just been sitting around. There's been a lot of discovery that has not been handed over yet, and we are not ready for this summer. So hell no, basically. So that's where we're at right now, Sean. Thank you so much for joining us.
And summer was mainly on the state side because of parking. I shit you not.
Parking. Yeah, or because there's a school across the road and a university, and summer's good because it's quieter around town. So let's do summer, shall we?
Available.
Yeah, like it's not like there's a man with a death penalty on the table. Hey.
Well, that's how the state operates.
Yeah.
Shouldn't be surprised.
Yes, paralegal is think of the children. Jeez, think of the children. Okay, I'm getting really annoyed, but Ann Taylor's good, so I like listening to her speak. How's your day?
It's okay. It's finally kind of calmed down a little bit. So
cool. All right. Well, sit back and enjoy. Let me know if you want me to stop and chat for a sec. Let's go.
Story. We have to be prepared to talk about that in different ways. But it's not just a English story. We're required to go 3 generations back on each side, mom and dad. The court can imagine that there are a lot of documents that must be collected and examined and reviewed so that we are aware of things that we would need to present to our jury if we ever got to that phase. We have had a lot of trouble collecting documents. Sometimes it takes a court order to get documents. Sometimes documents are missing. Sometimes they're very old and you have to piece things together. We're working through it, but I want the court to know it takes some time for that as well. There are records yet to be obtained that we need in both sides. There are still experts yet to be hired that we need to find an expert that has the right expertise, and we'll work on the case.
That takes time.
We do have several, we're working with them, but there are still more that need to be found. And then let's come back to the discovery. I want to talk about some of the difficulties with discovery, and I want everybody to know that I am not disparaging the state when I say this. I'm describing a complication, a challenge, probably one that the state shares. In this case, we began asking for supplemental discovery in February of 2023. We had some initial discovery, and then we started looking at it and asking for other discovery. We are up to our 11th request for discovery, and there's, I think, 250 items total with subparts to that. The state will respond to us. They're not ignoring us. I'm not saying that at all. There's just a lot out there. But this is complicated because the discovery that we receive, the materials, there's videos, there's interviews, there's police reports, there's photographs, 13,000 photographs.
And welcome. We just had Sean pop in, and now your good self.
Thank you.
Aren't we blessed?
Hey, folks.
Hey.
Hey, Bronca.
Have you been watching, or would you like me to give you a quick rundown?
I just jumped in now, so I've heard nothing.
No problem. Okay, so basically where we're at is the state has gone and said that they want to go to trial in summer of this year, which is kind of nuts considering that the defense has only just started to have some of the DNA evidence, the genealogy handed over, and only a small portion. And they, as Ms. Ann Taylor is now arguing on behalf of Mr. Kohberger, are still waiting on, I think, 60-something gigabytes or terabytes, sorry, of digital evidence. And there's still a ton of DNA evidence. They have to, she just said that they have to hire expert witnesses. Yes, brief them. And summer of 2024 is 5 months away. We're talking about a quadruple homicide. And there is the death penalty on the table. And Mo, as you so eloquently put it, why was the reason the state wanted to go in summer of 2024?
Parking. I shit you not.
Parking. Yes.
That's the reason they gave, was parking.
Yeah. It'd be
Well,
better
I mean,
parking.
among other things, but it's a small town. There's a high school semi-adjacent, and, you know, there's going to be a lot of people that want to come, and apparently parking would be an issue. And with all the experts that they would, you know, have coming in, there would be, you know, possible conflicts with lodging too, because apparently between the two colleges and sporting events and other things, the Motel 6s would all be full. I guess, you know, the prosecutor's taking someone home to his Airbnb.
Yeah, exactly. So, yeah, I mean, the thing is that in summer, apparently the school won't be there, and there won't be so much conflict with like busy streets and all that kind of thing. That's what they're saying. And Ann Taylor's come back and gone, hell no. And if you want summer, it's going to be 2025. But how about we just change venue? That makes a lot more sense, but we still need to put that motion forward. And before you say anything, we're not just sitting around. We're not just playing games, because, you know, that's pretty much preempting what they're going to say, because that's what they've been saying all along, that the defense is playing games. Yeah, she's really good. Love Ann Taylor. Very, very good defender. Yeah. Anyway, anything to add? Anybody before we move on?
I'm good.
Fairly decent synopsis. All right, so guys, if anyone wants to add anything as we go along, just let me know and I'll pause it. But so far, I'm happy with the coverage. Like, we've got good audio. It's working. Judge has made a good call, I think, in streaming it from his own channel. It's working pretty well.
That come in, and they are not indexed. So you get a discovery file, and there's tons of sub-files, and I believe this is the way the state's getting it too. And I believe this is complicated because we have multiple law enforcement entities that have been working on the case, and I believe they filter discovery through one of the entities, and then it gets to the prosecutor. And I think they're hurrying as fast as they can to get the discovery to us. So I think they're giving it to us as they get it. But there's no indexing in it. So you must open each of those files and see what you have. And you might have police reports in sequence, and then you might not. And you might have photographs, but you don't know which officer took them. You can tell where they are, but you don't know which officer, and you don't know what day, because the officers were in that residence multiple times. So that's complicated to try to match all of those things up. There are things that we've asked for that have taken, it's just taken a long time. The court knows we've had motions to compel, and we've had some pretty lively debates about what certain things that we should have and certain things that they don't want us to have for other reasons. Those things take time as well. We don't have complete discovery. I don't think the state has complete discovery, but we definitely don't have complete discovery. I'll give you a couple of examples. There is a video that's a really important video, and we early on received some of it. And
But how much?
We are still waiting for the complete of it. The court would know from our 11th discovery request that there's still outstanding portions of that video that we need to have. And I think the state's working through it, trying to match up video and sound together for the completion, the full several days worth of video. But there's not even an estimated day when we'll get that. And that is critical for us to review and hear all of that. So that's an example, Your Honor. That is not us saying we just don't want to go to trial, we just want to drag our feet. That is us saying there are critical things that we don't have. I am very concerned about expert reports. We have a draft of one, the CAST report. The court had ordered that we receive the CAST report. It's a draft. I don't think the state has it. I don't think they're sitting back on it, but I don't have that yet. And there are completed materials all over the place like that we just don't have. Our team speaks with the prosecution team fairly regularly about these issues. We communicate by text and by email about things like this that are coming up. We've sat down and spoken with them. They're very open to talking to us, but this just isn't a closed deal. There has to be a deadline on discovery. There has to be a target date where that ends. And then there has to be time to make sure that we've read every piece of it, watched all the videos, looked at all of the photographs, and know where they came from. A few months from now is not a sufficient amount of time to do that. There is no possible way I can even read or watch everything I have now or react to things that are still coming in if we're to have a deadline in time for a summer of 2024 trial. There is no possible way that I would be effective in my investigation, in my presentation to a jury, if I don't have the state's expert materials ready to get to my experts and then get them a report to respond to. There is no way that—
Sorry, what'd you say?
Constitutional issue. She's saying that if you compel me to do this, I will be ineffective assistance of counsel.
And she's putting on the record.
Case. Right.
Yep. Yeah, she's good. And yes, you. One thing I forgot to tell you guys is that earlier the state the defense said that the state is trying to kill someone. And yeah, the defense. Sorry.
Oh, sorry.
Sorry.
No, I'm sorry. I didn't mean to jump in. Sorry.
That was all I had to say.
Okay.
That was the wording.
Is
I
this
didn't like that at all.
Has this been the defense the whole time? Like, we were asking for discovery, but they're being pretty cordial with the state about it. Like, they don't think the state's playing games. Has this been how they've been handling it? Because in some cases, the state messes around. So
Sure.
I'm surprised they're getting along this well.
They're not getting along this well. They're just being very
That can
cordial.
definitely happen. I mean, I've worked on cases where I don't know. Can you hear me?
Yes.
Okay, all right. Sorry, I disconnected for a second. I wasn't sure if I broke something. But I've worked on cases where so I consult, right, to other attorneys, other defense counsel, and I've worked on cases where defense counsel didn't want me to consult, but the client did. The client insisted that they bring me in on the case, and then what often happens is defense counsel and I'm sympathetic. They don't want too many cooks in the kitchen, right? This is their case, their lead counsel. And they're worried that I'm going to muddy things up for them. They don't know me personally. But what they'll do is they'll send me like every irrelevant piece of evidence in the evidentiary file they can. They'll send me thousands of photos that like were an accidental photo of a cop's shoe. But of course, if it's sent to me, I have to look at every damn thing they send me. And it's just because they're just being dicks, you know. But if that's what defense counsel will do with an expert who's retained for their client, just imagine what the state will do. I've seen the state do stuff like there'll be like a huge pull of photographs from someone's phone or computer or something. Yeah. And they have to provide those to the defense, right? So they'll burn them on a DVD and provide the DVD to the defense. But there's thousands of these things. Yeah. And so they'll provide like a printed or a printable, like an Excel spreadsheet that lists all the items with a brief description that's on the DVD. And defense counsel, often they're overwhelmed. They don't have the staff to look at all these photos. So they'll look at the paper and they'll say, is there anything described that looks like it would be relevant to our legal argument? And the state will leave out descriptions of some of the photos.
I know 100% what's been going on.
Okay, so the state has been playing games.
100%.
The defense is trying to be nice about it, which I give them
being
credit for.
Extremely cordial in court. Yes, absolutely. But you know what? Also, the state has. I am 100% on this. They have people out there that are running this narrative in the popular media about the defense being the ones who are playing the games, and they are putting forth all these motions to try and get more information from the state. They are the ones who are like, oh, you haven't given me this piece of information, that piece of information. Oh, you're the one who has there's this thing with the genealogy, for example. Oh, it matters where you got the DNA evidence. It matters where you found the piece of touched DNA, how you match that up to me. So you basically, it was found through one of these websites like 23andMe or something like that. Yeah. And yeah, so it's fruit of the poisonous tree, basically. And so this is all hugely important to whether or not due process has been followed. But it's been made out like the defense is the one playing games, and the defense is the one who is putting things off. But as you say, every time they give a little, every time the state gives a little, they're only giving this little piece, and it looks like they've given, oh, they gave the genealogy stuff. No, they gave this much, right? And so it puts it off a bit more. He had to waive his right to a speedy trial. He had no choice. But it looked like, oh, okay, well, now it's just going to go on forever. So the poor victims, they have to wait.
And I expect this comment you have highlighted right now is very true. So this, every time this defense lawyer says, I'm sure the state's doing everything they can, she means the opposite of that. It's like a breakup talk, right? It's like, it's not you. It's not you. It's me. You know, that means it's you.
Yes.
Yeah, I was just, I wanted to double check because sometimes they actually do work with you. Most of the time, you're right, though. It is just here's a Cellbrite dump, dig through it.
This is not South Carolina where they're actually actively throwing shade at each other.
No. Didn't she say she had to put in 11 motions to, compel discovery?
Right.
Yeah. Yes, indeed.
Yeah, and I didn't know if that had finally stopped yet or not.
Yeah, an angry Santa Claus got up and said, please don't say we're asking for the death penalty.
Yeah, exactly.
Oh, they did say that?
Yeah.
I must have missed that part. Okay.
Yeah.
Wow.
The other issue is that Ann Taylor is one of the only death qualified attorneys in her part of the state. Yes. And this is not the only high profile DP case happening this year in Idaho. No, it's not. No. And so, yeah, she's busy. She's very busy. She's incredible, but she's busy. So, yeah, she's understaffed, under-resourced, and this is his life. It's his life, people. Let's just.
She's got a great speaking manner. I'll
up.
give that to her. She doesn't sound like she's whining or screechy. She just sounds like, oh, it would be so easy to agree with her.
Well, yeah, she's an excellent fact, and she's not. She's just laying it out very factually. She's trying to be, very logical to the point. She's just saying, look, these are the things that I'm having to go through. It's just A, B, and C.
Yeah. Hey, Fast Group, good to have you here. Okay, let's keep going.
I am effective assistance counsel, and I haven't looked at every bit of discovery that's available. Recently, Your Honor, as recently as January 4th, we received discovery that contained over 9,000 tips that law enforcement had obtained. And we've had, this isn't a new issue, I think courts heard about this before. We've had bits and pieces of tips, and they've come in and we've reviewed them, but the 9,000 new ones we received January 4th, those were closed out in October of 2023. And I don't think the state sat on them. I think that's an example of the process that they close them out so they can give them to us. But they go through other agencies before they get in the prosecutor's hands to give to us. I have to read every one of those 9,000 tips. There are things that matter to us in our innocence phase that have come up and been done, and I have to read them and appreciate them and react to them and see what's there. That's the duty I owe to Bryan. That's his right for effective assistance of counsel to have me do those things. Your Honor, summer of 2024, it's impossible for us to do it.
Not going to happen.
Our team constantly meets. We constantly work. We are on this. This is our priority. Bryan's our priority, but we are not going to be ready in June 2024. Your Honor, I want to also talk about some of the other deadlines. One of the things in the state's motion for scheduling order had to do with the alibi defense. And as the court remembers, we had made some submissions and we needed more information before we could do anything more complete. We're still in that circumstance. But when the court vacated its scheduling order last fall, that was part of the scheduling order that was vacated. So the state asserts in its scheduling order that our time has expired, and that just can't be, because the court didn't carve that out and say, I'm going to vacate everything but this. So we'll need a new date, but I'd ask the court to be really mindful of the other information we need. We need the cast report. We need other information of things that past agents and other specialists with the FBI might have done with cell towers and records. And I don't have all of those yet. I have some. And the state has pointed me to places that they believe I have more that maybe I missed in the discovery, and I'll look at those. But I'm going to need some time to do that.
Wow.
I wanted to let the court know as well, because the court's going to be considering a scheduling deadline for 12B motions. I want us to have a clear picture before we have that deadline. And the clear picture that I'm concerned about is the state's pathway of how Bryan Kohberger comes to their attention and is identified. I've read that PC affidavit over and over and over again, and I'm not sure. Over a year into this case and everything I've read, and I've spoken with our team, we're not sure how the state decides on Bryan Kohberger. I know different pieces, but I don't know where they fit together. And the more work I do, the less I know about how they fit together. And that is critical for us to assess 12B motions. So while the court's doing deadlines for discovery, I need the court to have something with the 12B keyed on when I have full discovery. I also think it would be appropriate for the court to allow windows to file additional motions based on.
Uh-oh.
Oh, what happened? Did he boomer?
Uh-oh, Brian got loose with a knife near the stream. So I mean, yeah, it sounds like she needs to file, like, their bill of particulars is still not very good at this point from the state about their theory of how even they can identify him or come about to knowing it's him.
Are you kidding?
I remember reading that piece. I remember reading that probable cause affidavit back when they released it, and it didn't make sense.
They moved it to
double check the stream.
They moved it to private.
They did, didn't they?
Yeah.
Ooh. How can we be this far in a case and we can't figure out how the state got him? I mean, this is
they do this all the time.
Shades of
Oh,
Delphi.
Yeah. Oh,
the state does this all the time. These
normal,
probable cause statements are
that
often they
not
turn out to be complete and utter garbage.
Delphi's garbage for a whole nother set of reasons.
Oh, yeah, I'm covering Delphi as a dumpster fire on top of a nuclear volcano with Sharknadoes.
Oh, that's possible. Yeah, they may have cut the stream because we paused. So we might not have got to the... They might have finished it. Damn!
They were like, don't talk
that
about
red
how we
bar
don't
is
have
not to the end.
evidence.
Yeah, but if they
Yeah, I know
private it before, I think that
If
kind
they
of killed
privated
it.
it before we finished
Oh, I
it.
see. Okay.
Whoa. That's so fast. That's so fast. Hey, Dali, could you have a little look and see whether it's like up on another channel in full?
Maybe Recovery Addict. Danny, it happened to her.
No. We can't run someone else's, like as in with commentary. I mean, like with Law and Crime or someone like that.
I don't think so.
Have restreamed it. Okay, never mind. I just checked Twitter and see whether or not there's actually been a date set. Damn. That was so fast. I was not expecting that, or I would have, well, I suppose there's nothing we really could have done other than gone at quadruple speed to try and catch up. No date set, Christy Reed, thank you. According to Kathy Russell, Judge said he's not inclined to pick a trial date looking at March in 25. Good. Phew. Well, it must have been
So
very long,
whichever
though.
side is pushing hard to go quick is the side trying to catch the other side off balance and unprepared.
Yep.
Trial. So the state is pushing hard to go quick. It's because they think they want to catch the defense off balance and unprepared. And by off balance and unprepared, I don't mean that's necessarily a defect in the defense. It could be that the state's case is crap and they want to get it in front of a jury before that can be exposed.
Yeah, I'm 100%. I completely see that, because honestly, all of the people that I trust in the law space on YouTube, and that's all I've got because I'm in Australia, seem to think that the state's case is very thin so far.
Oh, what I
We
just said
haven't
is
seen
true,
it.
and I don't know anything about the substance of this case, so I haven't looked at any evidence. Just as general
Yeah.
principle, whoever's pushing
Yes.
hard to go fast is trying to catch the other side off balance.
Yes. Well, I mean, I've been mainly following Andrea Burkett, and she is
She's
right
very good.
across. She's very good, and she's right across this case, every aspect of it. And I've been following every one of her updates on this. Every time someone asks her whether or not the state seems to have the right person on this, she seems to believe. She says she believes not at this stage, and obviously more could come out at trial. There could be a lot come out at trial. We can't know. We can't possibly know. And I will not ever make a judgment until I've seen everything come out.
But in an ideal criminal prosecution, nothing should come out of trial. Everything should be known ahead of time. There should be no new discovery of information. Everybody should know exactly what every witness is going to say, what every expert report is, because the purpose of the trial is not to discover evidence. The purpose of the trial is to have the evidence fixed and build a narrative of guilt and a narrative of innocence, the opposing sides, and present those to the jury on this foundation of the known evidence, and then the jury can arrive at a verdict. It's actually suboptimal when you have a witness on the witness stand and they say something unexpected that opens up like a new avenue of investigation. That shouldn't
awful.
happen. That's there's something wrong with that. It does happen, you know. But in a perfect trial, there'd be none of that. Everybody, all the participants would know exactly every word that's going to be said.
Yes, absolutely. Right. So I just found that whole thing with the state trying to get it to be September this summer ridiculous. That just blew my mind. And to try and make out like it was necessary because of parking and the school being out, being inconvenient to people in the area. And then also just because the victims would like to get it over and done with, basically. That's just, sorry. The defendant has rights, and this is his life.
Well, it's not only his rights are paramount to whatever the victims want. You know, that's the bigger thing there. Yeah, and we have that here in Ohio because I think in Idaho they might have a victim's bill of rights, and one of them is they have the right to demand a speedily resolution of a trial.
Really?
But they have the right to demand that, because otherwise if things are dragging on, they have the right to basically they get to come in and cry and say, this isn't fair, it's taking too long. Duly noted. Yes.
Okay.
Okay.
But at the end of the day, it's like, Your Honor, we need more time. It's like, well, both the state and the defense will get more time if they need more time. So
So it means nothing.
Yeah, it makes people like it got
better.
passed. Yeah, and it got passed, and the problem was you can't come out against that, because then it sounds like it's like to give up
You're against
everybody
victims, right?
Yeah.
well, no, it's to give everybody a puppy law. Like,
Right.
I don't think that's a
it's
good
the I
idea.
hate
Why don't you
children
want
law.
everybody to have a puppy? You know, nobody's going to say that's a bad idea.
And to be
and I don't
fair,
know how
I'm not
Sean
saying
feels
this to
about
be
it,
mean.
but-
It's
a lot of this
it's not about-
victims' rights stuff is awful. It's awful.
It is.
It sounds
It is.
good because we call it victims'
sounds-
rights, but it's terrible stuff.
That's the thing. It sounds good in theory. Like it sounds like all very cushy. And I'm not saying it because I don't feel sorry for the victims. Of course I do. It's a horrible thing to have to go through. But there's another victim in this. If there's an innocent man, and he is innocent in the eyes of the law right now, he is sitting in a jail cell and he's potentially going to be unalived by the state. And this is extremely concerning if he's not the right person. We should all be very, very worried about that. And if the state gets to have their trial too quickly and his counsel is not able to defend him properly because they've just managed to have their trial quickly because people would like to get it over and done with, that's just not okay.
Well, even
That
knowing
is
nothing
just
about
not okay.
the substance of this case, because I haven't looked at any of the evidence at all. I've only seen headlines and news reports, and they're worthless. But the fact, so long as the prosecution is not successful in accelerating the date, and it looks like they're not from that comment, the fact that they're making the attempt suggests good things to me for the defense.
I would agree.
Yeah, I don't think this judge
Very
is
much.
silly. Like, I think the judge will see, like, will be like, come on, that's ridiculous. Summer is 5 months away. That's, I mean, here it's summer here, but summer is 5 months away. So, I mean, come on. But I can just see exactly what people are going to be saying, and I'll have it on here, say, for days on Sunday. There will be comments right now about how, Kohberger, Ann Taylor, they're trying to push it out further. They're playing games. Let's get this done. La la la. It will be absolutely rampant. Coffin Duffer will be on it immediately. It's just going to be a shit show. So
she's terrible. She's a terrible.
She's your new friend,
mate.
Yeah,
mate, come and do a stream with me on her. I'm not.
she's your
scared
new
of her.
friend.
Hey, you know what, Bronca? She tried to DM me. She tried to slide into my DMs. And
she liked your tweets,
and she liked my dancing tweet as well. But I don't follow her, so she can't DM me. So
oh no,
too bad. All right, time to go. Hello, Paris River Show. Nice to see you.
Thank you very
EDB
much.
still watching it. How is EDB still watching it?
She has magical powers.
She
it's
has
the purple in the
magical
hair.
we'll have to
powers.
set up
How's she
private
still
feed
watching
next
it?
time.
Yeah, we'll have
she's
to
still
start
watching.
something. Okay, never mind.
Your
hair looks pretty, Mo.
I'm trying to see what she's
Thank
got
you.
going.
How's she got
She's
it?
using. Looks like she's using a YouTube.
Using a
It was
YouTube.
only on YouTube, but she could have been recording it in StreamYard.
She could have been. She could have been like recording it, or she just. Yeah, I don't know. Who knows? All right, whatever. It's fine.
Oh, I see what you're saying. So we were watching it, but we were pausing. So we were effectively watching the playback portion of the live stream, and then they got to the end and they ended.
And then he yeeted it. Yeah, it's yeeted. He's yeeted.
Well,
He yeeted it.
there's a. I've got it right now.
What?
It looks like the hearing is finally over.
Yeah.
But there's another channel that was WFLE News was running it. I'll send you the link.
Can you?
Yeah.
Oh, we can watch it. Oh, it's Sean, you legend. You know,
Yeah, I think if the state was rock solid and convinced of they had a case that was really locked in, they wouldn't care about the delay. They're just
they kicked their feet
prosecutors.
up.
They got to show up to work every day anyway. It doesn't mean anything different to them.
Oh, I
yeah,
agree.
so if
I agree.
If I just rewind. Oh, look. Oh, you are awesome. Hey. Okay, so where were we?
Well, that's the thing I don't know.
15 minutes left.
You think?
I don't
Was that
think
much?
Angry Santa had stood up yet.
Okay, so that's them just talking. So that'll be
Yeah.
the end.
Go back like 20 minutes.
Negative 13. So let's just see what they're talking about. And I just need to boost the sound and go ahead.
Sound together for the completion, the full several days worth of video, but there's not even an estimated day when we'll get that. And that is critical
We
for
heard
us
that,
to
right?
review and hear all of that. So that's an example, Your Honor, that is not us saying, we just don't want to go to trial. We just want to drag our feet. That is us saying there are critical things that we don't have.
Actually makes the ineffective assistance.
Very concerned
Yeah,
about
so go forward like
expert
5 minutes.
reports. We have a draft of one,
Yay,
the
Sean.
cast report. The court had ordered that we receive the cast report. It's a
Yeah,
draft.
go
I don't think the state
forward.
has it. I don't think they're sitting back on it,
Yes,
but
she
I
does.
don't have
We
that
heard this.
yet. And there are completed
David is
materials
not
all over the place
child.
like that we just don't have. Our team speaks with the prosecution team fairly regularly about these issues. We communicate by text and by email about things like this that are coming up. We've sat down and spoken with them. They're very open to talking to us.
Do you want to?
But this
go
just isn't
forward?
a closed deal.
Oh, yes.
There has to be a deadline on discovery. There
this.
has to be now would be been done. And I have to read them and appreciate
Yeah, we've done all this. Yeah.
other information of things that past agents and other specialists with the
We do
FBI might have done with cell towers and records.
Yes.
We haven't got
And I
the-
don't have all of those yet. I have some.
Mhm.
And the state has pointed me to
This is the
places that they
CAS
believe I
system.
have more that maybe I missed in the discovery, and I'll look at those. But I'm going to need some time to do that. I wanted
Or
to
the
let the court
alibi.
know as well, because the court's going to be considering a scheduling deadline for 12B
B12.
motions.
12B.
I
not
want
12s.
us to have a
This is new
clear
stuff, right?
picture before we have that deadline. And the clear picture that I'm concerned about is the
Yeah.
state's pathway of how Bryan Kohberger comes to their attention and is identified.
This is.
I've read that PC affidavit over and over and over again.
Yeah.
Have something,
Disclosures already.
Okay, we haven't heard him talk.
I think that covers it.
Thank you. One more question. So
Sure.
I understand this. I mean, aware amount of disclosures already.
Microphone, dude.
But do we need a whole nother year after this summer? I mean, can I help everybody by having tighter deadlines to make things happen faster so that we can
Well, they
get
were the
this,
ones who wanted a
trial
summer.
sooner?
That's a tough question. If the state says you have everything and I believe they could say I have everything they have, but I know there's other things out there.
Paris River
I know it
Show.
based on responses to discovery. If I had absolutely everything, all their experts' reports, I would still need a period of time to read and understand that. There's not a shortcut for the amount of time that it takes to go through everything. There's just not a shortcut for that. Having a deadline for discovery helps me. It just does. Having a deadline for expert disclosures, that absolutely helps me as well. I have the concerns of discovery that's not yet made available. I have the concerns of the time it takes to review all of the materials. And I have the concerns about the limitations we're finding with people being willing to talk to us, both for the innocence phase and the mitigation phase, should we ever get there. I have significant concerns. We're working on it. If you could say, everything's going to go according to plan, I'm going to give you these deadlines and all of the materials will be in the state's hands so they can give them to you. And the records you need will be given to you when you ask. And the witnesses that you need to speak with won't slam the door in your face. If you could tell me that, then I would say I could be ready by March of 2025. And that's me saying I'm going to spend every possible hour on Mr. Kohberger's case, which I've been doing and which I'm willing to continue to do, and so is the rest of his team. But my problem is that's best case scenario if we don't run into problems and delays getting records or getting people to talk to us. And if the next calls I make on the experts that I don't have yet secured, if they say yes and they're ready to go and have time to take it on, that's best case scenario. I'm nervous telling you I'll be ready by summer of 2025. I'm nervous telling you that.
This is priority for everybody, and I want to be realistic about it. I don't want to set it more than once. I only want to have one trial, one time, so it doesn't come back.
Then you got to stretch it out.
You know, we can only predict the future so much. I only have so much power. So I'm relying on counsel deeply. So
I mean,
let's go to Mr. Thompson and see what you have to say about all this. Just getting things ready for trial.
Ms. Taylor is not understating the amount of work that's involved in this case, Judge. I think that's fair to say, and there's more information that continues to be developed. You know, it's kind of like you ask one question, you get an answer, and that leads you to another question. I know that Ms. Taylor and her co-counsel and investigators are encountering that. We are trying to provide things as quickly as we can, and she's right. There are delays in with the multiple agencies getting everything together. The tips, for example, were part of a nationwide tip line that needed to be completely shut down before we could get all the tips that were in it. And so that's why it took so long with these 9,000. I didn't count them, but there are thousands and thousands of tips, most of which are out there. But you're right, most of all of which need to be looked at to see if they have any potential relevance to the case. As I indicated to the court, if we cannot have a trial this summer, then I would say the earliest would be the summer of next year, for the reasons that I've described to the court about the practicalities of carrying on a trial of that duration with the high school, with the universities. We need to be realistic about being sure that we can get our witnesses here. We'll have something to put them, and there won't be undue interruptions in the community that could cause issues with the community's perception of the trial proceedings. I'm not quite sure what else I can offer.
You're making some kind of argument that changing venue, but I know we're not arguing about that.
And, you know, I don't think that's going to change anything, Judge. You know, when this case has national, if not international attention. You know, this spring, I was at Association of Council of Counties board meeting in McCall, and there was more news every morning from Boise on this case than we see up here. Every doggone morning. I have people, friends in this community who have traveled to Mexico, and they say, people here were from Moscow, and immediately they want to talk about this case. It's not Moscow, it's not Latah County, it's everywhere. So I don't think that a change of venue is going to solve any of these problems. And the state's position on venue is that the case should be held.
That's what they always
here.
argue. That's what they argued in the Chauvin trial too.
We believe that we can select an appropriate panel of jurors from Latah County. We have the tools to work with that we've discussed with Your Honor. In fact, we already have a fairly comprehensive draft juror questionnaire to send out so that the court and counsel can assess the level of knowledge and the feelings of the potential jury pool. But we think that we at least owe Latah County, the people of Latah County, the attempt to seat a jury here first. And not just rely on, there's been a lot of publicity. There's been a lot of publicity everywhere. The only place I've heard that there wasn't publicity is in Lewis County. Somebody was talking to a court down there, and they happened to mention co-location. Said, "What are you talking about?"
Oh, for God's
So
sake.
if we want to change venue, I guess we could go to Nez Perce.
It's ridiculous. Okay, I can pause it now, and I'm just going to say that just because there's been a lot of publicity doesn't mean that the local people aren't more emotionally invested in it, right? Surely they are.
The question is not whether or not the jurors have ever heard about the case or have a personal interest in the case. The question is, can they be fair, impartial, unbiased as jurors?
Yes.
That's much more likely in a different venue than in the community where these terrible killings happen.
Yeah,
exactly. Exactly. That's exactly right.
Small.
It's kind of small. Lodgings aren't very good as far as a lot of lodging. But I think that is a practical observation on this case. It's not just here. It's not just Moscow. It's not just Latah County.
Thank you, Mr. Thompson. So you're saying, you're looking at this realistically and the amount of information, evidence, non-evidence, that might be looking at summer of 2025?
I'm saying that could be where we end up, Judge. I am still concerned about the victims and their families. I mean, they have suffered for well over a year now with a lot of uncertainty, and that's painful. It's an everyday reminder, and they need some certainty and they need some closure in a timely fashion. But we know we also have to make sure, as Your Honor just said a few minutes ago, that we only do this case once. That it doesn't come back on appeal, that it doesn't come back for subsequent things saying that somebody made a mistake. We want to do it right. And the factors are in front of Your Honor. I think that you're certainly in a good position to make the best decision.
It's a decision that pulls me in two different.
I appreciate that, Judge.
Yeah. I want to set it right now. I mean, I'd like to get a little closer with discovery and see if we can have that more quickly. I'd like to speed it up if it's possible. I'd really like to do this sooner than later. I mean, maybe March 2025, which Taylor, that would be a reach. I just want to let it percolate a little bit. I know everybody probably here, including counsel, want to direct a certain date.
No,
But
defense
when you're
counsel
talking
doesn't.
about a date so long in the future, potentially, maybe we can get to a point where we can move it more quickly. I'm not going to just let it hang for too long, but it's really hard for me right now to set something in 2025, even though that might be just the reality.
It's kind of your job, Judge.
There's lots of other issues to be addressed. I know there are going to be a lot of
Have we turned into
motions.
a feelings court?
There's going to be a lot of motions about the death penalty as well. So it's realizing to think that we have to have a case so far in the future.
Oh my God, he's so confused and
That's
indecisive.
What is the right thing for everything to
He should be running a daycare center.
Bronca, I feel like I've joined. I feel like I need to get a tie to take off.
We don't want
You
to
and
do
me are
this
on the
twice.
same thing. I'm
We
like,
don't
are you a girl?
Sorry.
Because
No,
no
Christine,
matter
it's not going to be
what
easy.
happens, okay, if he's convicted, it's going to be appeal, and
That's not okay.
that's also
Just provide a fair trial. The appeals are not your
My heart
problem.
goes
They're
out
not
to
your
We
job.
tune into Oprah
I
today.
can't even imagine the pain, the grief, because you can't really go forward with your life without this hanging over your head. So,
Well, the
sorry.
defendant can't.
Yeah, dude might get unalived by the state.
We'll see.
Yeah.
All right, so
Last.
I'm gonna contemplate a little bit. It's not like I have to set this within
Oh my
2 or
God,
3
this
months.
is not
apparently.
good for the defense. This is a very wishy-washy judge.
I want to do the right thing.
Oh dear Lord!
As long as he doesn't decide. Let's just let him not
So-
decide for a year or two.
But I'm not even
Does that
thinking about just
conclude
this
what we need
issue.
to
It's
talk
every
about
issue,
today?
right? Now
Yeah.
he has emotional buttons
so
that can be
touched.
pushed. The
Yeah.
state's paying
Taylor?
attention.
Okay, well, thank you all. We are adjourned.
You want your judge to be like a robot running an algorithm.
Yeah, that's
Not
right.
like the
Live from the Stream Center, breaking
Stream Center. It sounds kind of gross.
It does, doesn't it? What color is it?
It's like,
Oh no.
are we in a Mexican porta potty? What's going on?
Oh no, not the stream center.
And what this judge could have said, he could have said, look, let's just pencil in March 1st, 2025. And as things change over the course of the next, whatever, 15 months, if we have to make adjustments, we will.
Exactly.
Yeah.
But no.
Yeah.
I need to let it percolate.
It's like
It's
someone
like
who
when
knows they know the decision they have to make, right? But it's an uncomfortable decision, so they're just like, well, let me think about it. Like, what? Actually,
And
no.
yeah.
Why do you need to think about it? you know what the only decision is that you can.
And here's the
reasonably
thing.
make.
Yeah, and here's the thing. Like the judge in the Murdaugh trial, Judge Newman was not a good judge, but at least he made decisions. This is going to be this is more unbearable.
It is. And
What
he's
happens when
been
there's
this way
objections
all
at
along,
trial?
actually.
He's going to say, "Well, I got to let it percolate."
Yeah,
So
well, I need to
guess
go
we'll
take
come back
10
tomorrow.
minutes. Yeah.
Okay, this is like when you have to say that obligatory, like, look, I respect and adore all women, but women can do really cool things, but Kathleen Kennedy has destroyed Star Wars. It's where you have to look, we all baseline acknowledge that what happened, this crime is bad. This whole pandering to the victim thing, I don't get it. I understand that there's a Bill of Rights, but this constantly feelings and victims thing,
Well, it's the drama of it, and the drama feeds into law and crime and all these crazy. Like, I always forget that woman's name, the former FBI woman, whatever it is.
Yeah.
All she does is post
Coffin
emotionally driven, estrogenic nonsense every day. Because I think I blocked her finally on Twitter because I couldn't take it anymore. But none of it is reasoned. None of it is evidence based. None of it is due process constrained. It's all just how she feels emotionally about whatever the parties are, and it's like she turns everything into a soap opera. And this guy is going to get executed if he's convicted.
Yeah.
So sorry, I don't care that you worked for the FBI. I've spoken at the FBI Academy in Quantico. It's I've met you people. Some of you are really impressive, and some of you less so. You're less so, ma'am. You're not all you think you are. And I just despise how. I guess they must make a lot of money on the clicks and the whatever on the internet because people love drama, especially, no offense, ladies, but ladies love their drama. That's what the soap operas were designed for. And she's providing that to that community.
Dali likes the drama too, don't you, Dali?
Oh yeah, I love it.
Yeah.
yeah.
Hello, Lefty. What's going on? YouTube censor doesn't like you. Well, fair enough. You put eggplants everywhere. Good to see you. Okay. Oh, her name's Nancy Grace. No. Nancy Grace is next level. We're talking.
Nancy Grace is horrible.
Yeah. She's Ursula.
Don't say her name again and she'll appear. It's like blood.
Don't say it 3 times. Please, whatever you do, don't say it 3 times in a row.
Boom. Yep. Actually,
she'll appear naked.
Whether or not she saw Nancy Grace.
She almost did that once on TV.
Oh, look, that's one character I won't buy a wig for.
Yeah, she was on Dancing with the Stars and her boobs almost whipped out on one of the things.
That's right. You told me that in private chat the other day, and I was like, that was a good thing.
Yeah.
What are you talking about, Sean? What? Yes, she's a demon. She is Ursula. She is actually Ursula.
Yes.
Little Mermaid. Yeah. The witch, the underwater witch. That's the one. And Nancy Grace did more in the last 20 years to destroy the presumption of innocence in this country than anyone in history ever could. Yes, that's why she's best friends with Jennifer Coffinlicker. You see, like, also, yeah,
because harpies fly together.
Bad news, guys. She's got Coffinlicker is starting her own podcast.
Even worse than being a harpy, she's a former Fed.
Yeah.
Okay, do you think she'd invite me on if I dressed up as Taylor Lorenz? I mean, just asking for a friend.
Yeah. Okay. don't worry, Christine. It is going to go to trial one day. It's just not going to be this year.
Yeah.
So, and that's a good thing for the defendant. It's a good thing. And when I say not just a good thing for the defendant, it's a good thing for justice. Because, come on now, it's not possible for him and his defense to possibly defend against the state and their unreasonable amount of resources in comparison to the very small amount of resources that
the state always effectively has infinite resources. I mean, that may not literally be true, but for all practical purposes, they have infinite resources.
Yes, and I actually had an argument with someone on Twitter about this recently, actually in Coffin Liquor's comments, because someone was saying that this guy seems to have unlimited state resources. He can have all the experts that he wants. He has the best lawyers, la, 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 la. Like, no, there's no such thing as unlimited resources. And also, this guy, he has the death penalty on the table. His life is on the line. He's fighting for his life. And you know what this person said? They said he didn't care about that when he took 4 lives.
Yeah, I know. They presume him guilty, which of course is the opposite of the legal reality. So is Kohberger, is he an indigent defendant? Has he got a public defender?
Yes.
Yeah.
So is she, I don't know actually how it works in Idaho. So in some jurisdictions they have, like in Colorado and Florida, we have like full-time public defenders. There's a public defender's office and people get assigned. In other states, they'll just take like a private criminal defense attorney and basically assign them to the job and say, we're going to pay you, public defender wages to defend his client. How do they do it in Idaho? Is there like an Idaho public defender's office and she works for that office? And she's
I think she's a private attorney.
I think
she sounds like a private attorney.
Yeah.
That's why I'm asking.
I believe so.
What I was going to say that is there are.
Yeah, it was outsourced.
Well, yeah, it's just. Yeah, I don't think she's court appointed though. I think she is just regular with the PD's office there.
Oh, Line Road knows everything. Ann Taylor is the public defender there.
Yeah.
Oh, okay.
So she's probably for that county.
Okay.
Although it's interesting. I didn't know that's how you pronounced it, so that's nice to hear they pronounce it right.
Yeah.
I always didn't know how you pronounce that.
Yep. And what's the other thing that I wanted to put here? My boss gets appointed, so I work on. Oh, right. Sorry. No, there was something else. Yes, this other thing. They've been talking about wanting to give him 4 trials. So, yeah. So splitting up the 4.
That the state's got a question. The state is gonna. They aren't sure about their case if they're doing that.
Yeah.
I want to see that. I want to see that argument from the state. That's ridiculous.
Yeah.
Because it's not like these people were killed at 4 different locations or something.
Yeah, and it's normally they'd be pushing for a joint trial anyway.
Yeah.
Right, because they.
Right. Yeah. So they get 4 chances at. God.
Yeah.
Yeah.
Oh, that is wrong.
Yeah. Okay. So thank you very much. I appreciate so much these very learned attorneys coming onto my little channel and gracing us with your wonderful commentary. And of course, I always am thankful for Ms. Mo and your time. You are busy with your various streams every day. You stream more than anybody I know. And I don't know how you do it with 6 children. And you're always amazing. And your insights are always appreciated as well.
Thank you very much.
And Dali, I just love you. You're my other half on YouTube. You're my YouTube puppy. What's this? One more thing. The crazy thing with Ann Taylor was the mess that happened because she's represented 2 of the victims' parents as PD. Oh, really? I didn't even know that. Love the accent. Thank you. Please subscribe. Come back. Hear more of my accent. That would be fantastic. Even become a member. I just lost the accent for a minute.
I was about to say, it's all fake. She's from Tallahassee.
I'm from Tallahassee. Actually, I don't even know if that's the right accent.
No, there's no crack in the background. It can't be Tallahassee.
Hang on, just a minute.
Not a gator.
I hear it. It's down there. All right, that's my 2 streams today. Honestly, I'm trying to catch up to you, Mo. I did 2 streams in one day, and it's now 8:40 a.m.
Yeah.
Well,
Amazing.
I mean,
Now I get to go to bed.
One of your
Yeah.
streams wasn't a 4-minute where you were dressed up as Taylor Lorenz crying. Okay, so
No, I'll give you that. I will give you that. Just before I go, Branka, have you got anything to talk about?
Not really. Get my free book, Law of Self-Defense Principles,
Get your free
lawofselfdefense.com/free book.
Give the free book. Okay, I'm going to put your link
Free
up.
book?
And
Yes.
also, Mr. Potentially
Yeah.
Criminal,
Oh.
do you have anything to talk about?
Yes, I do. Sorry, I didn't mean to step on your Bronco there. We're going to be finished up Michelle Trakunis, I think, day 10 today. We're going to review the WWE, the lawsuit against Vince McMahon. We started reading that last night, and there's too much of it. I can't.
Really?
Oh yeah, no, it's it's
Sorry,
very. There's a lot of
what-
questions in it, and
yeah.
also
Sorry.
Trump just got stroked for 83 million, because apparently the lady who says women like to get raped is totally believable, incredible.
Oh God. Okay. Right.
Yeah.
Okay.
Well, I mean,
I've been missing all that stuff, so
Yeah.
I didn't even know who Nikki Haley was.
Well, no, I'm talking
I
about
saw-
E. Jean Carroll, not
Yeah.
You're not missing
Right.
much with Haley, to be honest.
No, I saw the meme of Will Folks in the back of a car with Nikki Haley thing. That was hilarious.
Yeah, apparently Cadillac's
Apparently
her car choice.
Yeah.
Yeah.
Thank Bronco
And
for
now
writing
that
that
guy-
book that saved you for me. Oh.
And now that guy is hitting on paralegal Liz. She met him at the Murdoch hearing today.
Oh yeah, Will Folks has been hitting on Liz. Yeah, apparently. Apparently. Yeah. Okay. And everyone sub to Mo and to Dali. And one more thing before we go, and that is tomorrow, Jensen's stream for Dali is at 2 p.m. And then we have Becky Mails, and the Becky Mails stream is going to be a special pre-mid evidentiary hearing Becky Mails reaction stream. So make sure you're there for that. Of course, we always have so much fun on the Becky Mails. Here we go. I'll just put it here. I'll just put it in chat so that you know what it is. There we go. Okay, so the Becky Mail special, and as per usual, as it is now even more dick in the box, the Becky Mail special pre-mid retrial evidentiary hearing reaction show inside Becky Hill's inbox live tomorrow. That's at 4 p.m. Eastern. Don't miss it. That's tomorrow. Yay. Okay, I'm going to let you all go now. No more blurring on from me. Oh, hey guys. I thought you were done. We were almost done. And then we got another feed from the court because Sean found it for us. And we could watch the rest of it. And that was fun. Thank you, David, for popping on in. Jensen there. Yes, be there or be a cucumber.
Yes.
Indeed. Lovely. Thank you, everybody.
All right,
Love
guys.
you all. Have a
Take care,
great
guys.
day.
Have a good
Bye,
day.
everybody.
Bye. Bye, bye, bye. Bye, bye, bye. And where's my goodbye thing? I always lose it. Oh, there we go. Bye.